Hello, and welcome back to NatSec EmTech. With me today is Alan Cohn, the chair of the Financial Innovation and Regulation Practice at Steptoe. Alan, welcome back to the program.
Thanks so much.
If you could allow me to play skeptic here for just a moment. So if you have a nefarious actor who wants to use cryptocurrencies, well, there's a couple of problems with it. One is this idea of suspicious activity reports, or SARs, as being effective against something like terrorism. Anti-money laundering or money laundering basically takes dirty money and tries to make it clean, whereas a lot of terrorist operations take clean money and basically try to make it dirty. So post 9/11, when the Bush administration said, well, we're just going to insist that we have SARs everywhere, what ends up happening is, all males aged 18 to 32 from certain countries end up having SARs filed about them because there is no dirty money that's being made clean there. So they're just basically blatantly profiling to try to do this. So that turns out to be a very ineffective mechanism. And in the meantime, it makes it harder to find money launderers because you have a system flooded. So here you have a similar situation where you have know your customer rules, which are central to AML. And yet you have wallets which are not necessarily tied to specific identities that are doing the trades. You have mixers, right? So it goes into a system and it's pulled out at a different point, potentially by different wallets. So really, how effective are these measures in responding to national security threats, for instance?
Well, I think, just like in any part of the financial services industry, it's always a game of cat and mouse, right? It's always a race between those looking to exploit financial technology and those looking to police it. And it's no different with respect to cryptocurrency. And there's a couple of things that are important to note about cryptocurrency when it comes to anti-money laundering and the concerns that you raised. So number one is that while cryptocurrency wallets are pseudonymous, they are not anonymous, meaning that while each cryptocurrency wallet is just designated by a string of letters and numbers, each wallet is unique. And so there is the potential to match the wallet to an identity. At a centralized exchange or another entity that conducts know your customer checks or customer onboarding activities, a person's name and biographical information is going to be associated with cryptocurrency wallet or wallets that they use on that platform. So there is the linkage. The linkage begins there. Second is, because of the nature of that blockchain, particularly that distributed ledger, that chain of sequentially numbered, previously validated blocks that contains all of the transactions going back to the inception of that particular cryptocurrency, those transactions can all be traced. And there are companies, a whole industry of companies that with contracts with both private industry and government that use that information to not only kind of create chains of transactions, but also relational graphs and other kind of visual representations of how wallets interact with other wallets. And those entities not only use the information from the blockchain, the wallet transactions, which are all public. You can see the sending wallet, the receiving wallet, the amount that was sent, the date, the time, and the transaction number, the numbering sequence for that blockchain protocol. But those services also will do dark web scraping. They'll do open internet scraping. They'll look at records from criminal prosecutions and other types of open records and be able to associate additional identities with other blockchain wallets. And then through the relational analysis, you can begin to see the patterns. And even though there may be holes in the map, you can begin to see how wallets relate to other wallets, and then the identities that you do have, how they relate to the transactions. The third thing is, in the traditional financial services industry, when someone comes to open an account, the financial institution will take down information about the person presenting themselves, right? So they may ask their address, their name, their employer, the source of funds, all these things, date of birth, alternate spellings of names, prior names, and they'll record all of that. And that will be the identity of the account holder. And they will use that identity and the information provided by the person as a proxy for the provenance of the funds. Because they don't really know the provenance of the funds. They only know what's being represented to them, particularly if the person is presenting cash to open an account. With cryptocurrency, you do not need to rely on the identity of the person presenting themselves with the wallet to be able to explore the provenance of the funds, because you can use blockchain analytics to look at, okay, well, here is the wallet that is presenting the funds. It may be identified with this particular person who we know who that is, but now let's look back 1 transaction, 2 transactions, 3 transactions back, or let's look at a relational graph of how that person's wallets interact with other wallets, what other wallets are associated with that person. And you could begin to put together a picture of the provenance of funds that may be very different than what, for example, a person presenting themselves to a financial institution might say about the provenance of those funds. And so I think that the situation with cryptocurrency isn't necessarily better or worse, it's just different. There are things that can be done in the traditional financial services industry that are harder to do with cryptocurrency. And then there are things that can be done with cryptocurrency that are much harder to do in the traditional financial services industry.
So, how are more recent state measures impacting this picture of legal authorities and framework, at least within this primary AML sanctions illicit finance bucket?
So sanctions and anti-money laundering are largely the province of the federal government. Where the states come in is in a couple of ways. Number one, most states regulate money transmission as well. So they have concurrent jurisdiction over money transmission. And many states require entities engaged in money transmission to get a money transmitter license, or an MTL. Um, it varies across the country as to whether an entity that engages in transactions using cryptocurrency needs a money transmitter license. In some states you don't. In some states you do if you are exchanging cryptocurrency for fiat currency, but not cryptocurrency for cryptocurrency. In some states you need a money transmitter license if you're exchanging, cryptocurrency for anything, another cryptocurrency or anything else. In some states it may depend on whether it's stable coins or not. And in certain states, New York is the best known, they have specific licenses that you need to have in order to engage in, for example, in New York, virtual currency business activities in New York or with persons, with New York residents. And so that BIT license that New York maintains looks much more like what you would see a bank or another financial services institution obtain than it does like a money transmitter license or an MSB registration with FinCEN. That's much more an examination of finances, bonding, compliance programs, things of that nature. And in addition to the license itself, it comes with with prudential supervision by the regulator. And prudential supervision adds that layer of beyond just what the regulations say. It gives the state a say in, is what the institution doing prudent and consistent with good practice in the state. The next step up from that is that a number of businesses in the cryptocurrency industry, maybe stablecoin issuers, exchanges, others, have chosen to seek and obtain state limited purpose trust company charters. So these existed before cryptocurrency. They're not specific to cryptocurrency companies, but they are basically trust companies of other types obtain these licenses where they don't want to offer the full services of banks, but they need to engage in certain regulated activities, and they have that same type of heightened scrutiny, regulatory requirements by the state, as well as that layer of prudential supervision. And what that does is it gives the cryptocurrency company a higher level of confidence from that state and from other states about their compliance posture. And actually, in many instances, you will see, and you have seen over time, different cryptocurrency companies use that as a competitive, try to use it as a competitive advantage against their competitors. They say, well, we are regulated by the state of New York. We have a bit license. We're a trust company, so you can trust us more. Which is interesting, of course, because the premise of cryptocurrency to start is that the trust is not in any entity, it is in the code, it's in the protocol. In this instance now, this is a combination of a centralized entity with a certification or approval by a state, and that's what you should be trusting rather than the code.
You mentioned that if you were doing business with a New Yorker, you have to get a bit license. So say I'm a Swedish company and I don't even advertise to the United States. I just have set up a cryptocurrency in Sweden. And a New Yorker happens to find this cryptocurrency in the online environment, in the internets, as they say, right? Online. And they decide to start trading in this cryptocurrency. Does the Swedish company also need to have the bit license from New York in order to be able to do that, even if they're not advertising to New Yorkers, operating in the United States, founded in the United States, have no connection whatsoever other than they happen to be available, through the internet and others can trade with them online?
Right. So this is actually an issue across all the buckets that you identified, is this question of what does it mean to do business with the United States? And in this instance, what does it mean to do business with New York? Um, and and although it started in different places, it's basically converged to a point where um, you need a license, registration, or to comply with U.S. law if you are engaging in primary sales activities with a U.S. person, or in this instance, the question that you asked of the person from New York. So it is not enough not to advertise your services to U.S. persons or to New York persons. You must take active steps to block those people from your platform. And there's a number of tools that you can do that. Commercial companies have tools that allow you to geo-block people from your websites. Your own KYC or customer onboarding processes should include, for centralized entities or administrators, processes to know the identity, but also the location of people who are engaging in primary activities. In terms of, though, finding the token online on a decentralized exchange somewhere and bringing it into the United States on your phone, or trading on a decentralized exchange where there are not
What if you never
geographic
put it on your
controls.
phone? Do you actually have to bring it? Does it go anywhere when it's in the online
Well,
environment?
it's an interesting question,
Or what if
right?
you use a VPN, right? Like,
Right,
so,
right.
so you might have a geo block on the United States, but you're not actually downloading it onto your computer, right? You have a wallet that's based somewhere. What if that wallet is overseas?
Right, but if the wallet sits, for
Ostensibly.
example, right, but if it sits on a phone with a 212 area
Like
code,
if you add it to your browser on a
right,
device that's inside
right,
the United
right.
States, kind of an
And
issue.
then you walk into the United States, cross the border with the phone, and you're carrying the monetary instrument. Um, the obligation is to prevent the primary selling or the primary use of the platform. If you have issued a token and you have blocked U.S. persons, or you've blocked New York persons from accessing it, or selling, you don't sell to them, they can't access your platform, but they happen to get it through some other means, that typically does not flow back to the
Mhm.
issuer. But the issuer's obligation is to take active measures to make sure that they are affirmatively blocking persons from the US or from New York for whom they do not have the requisite registrations, licenses, or compliance programs in place in order to deal with US persons. And that's now pretty common in the cryptocurrency industry, where entities will either geo-block the United States or geo-block New York and certain other states, or they will have one entity that will service the United States, but not elsewhere, and they'll have another entity, a sister entity, or another entity that services the rest of the world, and you keep those segregated because the U.S. has relatively distinct requirements. And actually, more requirements, particularly in the anti-money laundering and sanctions area, than most other countries in the world up until relatively recent.
Although ostensibly they could operate on the same blockchain.
Yes, yes, because it's not the protocol is just code, um, and there have been cases about that have involved, well, if you are operating and if you have the blockchain, if the protocol is operating a node in the United States, is that enough to create a nexus, or do you really actually have to be transacting with U.S. persons? And um, the ultimate decision on that has been, no, that's not enough of a nexus, but best practice can be for non-U.S. entities not wanting might want to make sure that they're not implicating U.S. jurisdiction, is to use non-U.S. infrastructure of all types, and make sure that nothing touches the United States. That may evolve now with the new administration and the kind of the new posture towards the crypto industry, and a posture not just of, we're going to create laws and regulations that govern the industry, but we want the industry to come here. We want the U.S. to be a center of cryptocurrency activity, as opposed to what really felt like in previous administrations. We just want this out of the United States.
And you mentioned New York, but California, there are other states that are moving into this area. Is there innovation going on, or is it follow the leader?
Well, you have two kind of directions. Um, there is a certain amount of follow the leader when it comes to the bit license regime, the idea of a prudential supervision and regulatory regime for virtual currency or digital asset activities, that is largely based on the bit license model, which has evolved over time to include a process of approving and whitelisting certain tokens, as well as platforms and other things. There's also another thread of activity, which you see most primarily in Wyoming, but also in other states, of innovation and trying to make the state more hospitable for the cryptocurrency industry. So clarifying laws around money transmitter licenses to make the barriers for entry easier, creating new forms of financial institutions that can do business with cryptocurrency industries and handle cryptocurrency more easily, creating new legal forms. So Wyoming has created a legal form for decentralized autonomous organizations based on the LLC model. And so there is definitely innovation along that thread as well, to try to make states more hospitable locations for entities to do business in cryptocurrency.
Great. So let's turn to the second bucket, right? Which is, I, I would guess that typically, if somebody is thinking of launching a cryptocurrency, this is the first thing they would think of. Although I'm not sure as an attorney what you would recommend. Maybe you focus first on AML and sanctions and then on securities, commodities, and market structure. But this is another big area of the law that there seem to be a lot of questions as to what exactly a cryptocurrency is.
Right. It's a huge issue. As attorneys, we tend to counsel people to think first about anti-money laundering and sanctions compliance, because if you get that wrong, there's the chance that you can go to jail over that. And jail is bad, and we don't like to see clients go to jail. So we strongly recommend that people not skip over that bucket. But in the what's interesting about the securities and commodities financial instrument market structure model area is, when you're talking about anti-money laundering and economic sanctions, uh, those agencies and those regimes are really saying, look, we have rules for handling value. Follow those rules. In the securities and commodities space, what you see more is we're trying to characterize these instruments as something that fits within our existing regulatory schema. And unlike most countries, the United States does not have an integrated financial regulator. So in most countries, securities and commodities and other types of financial instruments are regulated by the same regulator. In the U.S., whether something is a security and so in another country, in most other countries, whether something is a security or commodity doesn't matter all that much. It's just, how is the regulator going to regulate that? In the U.S., whether something's a security or a commodity matters because it grants or removes jurisdiction from that regulatory agency, and of course from its congressional oversight committee. And so those are some of the thorniest issues that come up in clarifying U.S. law and regulation, is where issues of jurisdiction get mixed in with these substantive questions around what are we trying to do. So the Securities and Exchange Commission, their mission, right, is to protect market integrity and do investor protection. And they do that by ensuring information disclosure and making sure that markets are operated in a fair and open manner. And they do that for securities, which are defined under the Securities Act and the Securities Exchange Act as a set of enumerated entities, stocks, bonds, notes, as well as what's called an investment contract, which is like a managed investment scheme, a passive investment scheme, where you would invest money and earn profits based on the efforts of others. For the SEC to have jurisdiction over cryptocurrencies, they have to fall within one of those categories. The commodities regulator is a little different. The commodities regulation is really largely about risk transfer, right? Who bears the risk associated with the value of commodities, and how do you stabilize the value of commodities and the trading of commodities over time. And so it's a little bit different. Is an agency with a little bit different focus and a little bit different mandate. Each agency's has claimed kind of full jurisdiction over cryptocurrency. But to do that, the SEC had to say cryptocurrencies are securities. Now, most cryptocurrencies do not convey equity. They don't represent debt. They don't carry profit interests. So they have to fall under what's called this characterization as an investment contract. So an investment contract, again, is an investment of money in a common enterprise with an expectation of profit based on the efforts of others. And this is based on a case from the 1940s where there was a hotel in Florida that was in the middle of an orange orchard. And they would sell rows of the orchard to guests of the hotel, which is that's a real estate transaction. But the guests typically lived in different places. And so what they offered alongside was a service contract from a related company, where they would take care of the orchard. They would water the orchard, they would take care of maintaining the trees. They would harvest the oranges. They would ensure their sale, and then the owners of the orchard would get the profits, and they would pay a fee to the service company. And so the hotel maintained that was just that was a real estate sale and then a services contract. And what the SEC alleged and what the Supreme Court ultimately found was that was in fact an investment contract, because there really wasn't an expectation that the people purchasing the orange orchard trees were going to come down and harvest the oranges themselves, kind of squeeze them out and sell them to minute bait or whatever they were going to do. That really this was that taken together in its totality, this was an investment scheme. And so that was kind of the origin of, or the kind of the signal case regarding investment contracts.
This is SEC versus Howey, 1946.
Yes. And Howey was the company selling the orchards, and Howey in the Hills was the maintenance company. And so the question that kind of bedeviled the cryptocurrency question is the SEC alleging that the cryptocurrency is the contract, or is the cryptocurrency the orange? The orange is. And the investment contract is maybe the original, the primary sale of the orange? Is it the secondary sale of the orange? Is it every sale of the orange? And what ended up happening was the SEC over time went from alleging, well, because of the marketing and because of there's no functionality yet of the blockchain and you're pre-selling the token in order to build and you're making promises and all this kind of stuff, that makes this sale an investment contract. They kind of migrated to a position that they took in court in a number of cases under the last administration, that if the token was sold as part of an investment contract, then that made the token a crypto asset security. And it made that a crypto asset security for its lifetime. And the only crypto assets that potentially weren't that the SEC was willing to rule out of that were Bitcoin, because it was originally mined out. There was no pre-sale. There's this atomized governance. There's no centralized governance. And Ether, even though Ethereum grew up in a very different way and looked a lot more like what an investment contract might look like, the SEC said in a speech, one of their division directors said, well, perhaps at the time of its sale, it might have been a security, but at this point now that it's decentralized and functional and people rely on it and use it, there's no point in enforcing the information. There's no information gaps. There's no point in enforcing securities laws. So that kind of created this kind of muddied water of, is it just because Ethereum has tenure? Was it too big to fail? If you do everything that Ethereum does, are you not a crypto asset security? So it's a very confusing situation.
So crypto's an orange if it's Bitcoin or Ether. But otherwise, the SEC gets jurisdiction over it as a contractual matter in this rather expansive understanding that then comes out recently. Has the CFTC followed suit? Do they also understand it in a way that coincidentally gives them more power over it?
Well, so just to finish the story,
Yeah.
the Trump administration came in and said, that's a ridiculous interpretation. And we're not doing that anymore.
Okay.
And so they withdrew all those cases, and they stopped using that terminology. And they begun issuing guidance and no action letters that seem to infer that if you sell a token for capital formation, like a pre-sale in order to build a protocol, or you do a bulk sale potentially to investors, or that may be an investment contract. But it's that sale that is an investment contract. It has no impact on the token, which is just the subject of that contract. Subsequent sales have to be evaluated on their own basis to determine whether or not those are sales of investment contracts. And according to no action relief that started to come out, it looks like it's generally to be no, unless you're talking about a capital formation event, then particularly secondary sales of tokens and presumably other primary sales for the purposes of the utility of the platform or for payments or for other things are not going to be considered sales of securities. So that's a 180-degree shift. But the SEC is clear that they want to preserve their jurisdiction over capital formation using tokens, and then also tokenization of assets where the token represents an equity interest in something. And so if you are tokenizing a security, or you are basically using a token to securitize something, then the SEC is going to retain jurisdiction over that. The CFTC went the other way. Even before the SEC got involved in crypto, really, the CFTC asserted that cryptocurrencies are commodities. And they were backed up by court decisions.
Which coincidentally gave them control of
Gave them jurisdiction.
Yes.
Which potentially would have made them the primary regulator of cryptocurrencies, except that under the Commodities Exchange Act, the CFTC does not have jurisdiction over spot trading of commodities. So if you think about pork bellies or orange juice or other things like that, other traditional commodities, if you purchase those commodities and those commodities are actually delivered to you, to your facility or to a bonded warehouse or something of that nature within 28 days, then that's considered a spot transaction. And the CFTC does not have jurisdiction to regulate that. They have anti-fraud jurisdiction, but they don't have general regulatory jurisdiction. Where their jurisdiction comes in is over futures contracts and derivatives and margin trading and all sorts of other things that people were doing in the crypto world, and that they largely then kind of cracked down on and said, no, you either have to be licensed, registered with the CFTC as a particular type of CFTC registrant to conduct that activity, or you cannot service U.S. persons. So they have always maintained that they have jurisdiction over cryptocurrency, but they lack this spot trading jurisdiction. So you have this gap of spot trading generally being secondary trading. And if the SEC was trying to reach secondary trading through this crypto asset securities theory, the CFTC couldn't reach secondary trading because it doesn't have spot jurisdiction. So there was a potential hole. What the Trump administration has said is SEC and CFTC work together to fill these gaps. If work out with each other where you think the jurisdictional lines lie, and put out guidance to that effect. At the same time, Congress has been wrestling with market structure legislation to actually put structure on the market and say these categories of activities or these categories of instruments are governed by the SEC and the securities rules. These are governed by the CFTC or by the commodities or derivatives rules. And in fact, in legislation passed by the House, they have kind of more neatly divided jurisdiction defined for the SEC for its pieces, defined a category called digital commodities, which would cover a large category of digital assets. And then that would create a set of new digital asset specific CFTC registrants that would then be authorized to conduct trading of different types. And that would give the CFTC both spot trading jurisdiction and futures and derivatives jurisdiction. That's run into some problems in the Senate for two reasons. Number one, you have to navigate two different committees. They were able to do it in the House with the Banking Committee and the Financial Services Committee and the Agriculture Committee. In the Senate now, the Senate Banking Committee and the Senate Agriculture Committee are trying to navigate that. The other thing that happened was over the summer, both houses of Congress passed the Genius Act, which was legislation regulating the issuance of stable coins in the United States. And that was signed by the president. And that went very quickly for legislation. And I think that the traditional financial services industry, the banks in particular, got caught a little off guard. And so they are trying to litigate out some points in market structure legislation to try to correct some provisions in the Genius Act that they don't like, particularly focused on when and who can issue holders of stablecoins yield on those stablecoins. Can that be issuers, who the Genius Act currently prevents them from doing that, but other entities? If you hold your stablecoins at other entities, they can pay yield, and banks are very concerned about that. So right now, you have different conceptions of market structure, how the market should be structured between the Senate and the House. Those differences are closable, but they are different views on how you get there. And then you also have this question of, do we change these provisions of the Genius Act regarding stablecoins in market structure, or do we not? So this is now, as we sit here in February of 2026, something that we're going to be looking at, that I think the industry is going to be following really closely from now until the midterms, to see if we can figure out a way to get market structure legislation through. Because again, to go to your point about that you made in terms of anti-money laundering, it really doesn't and hasn't helped the industry to kind of paint the entire industry as non-compliant or criminals, but non-compliant. Because what that does is it doesn't actually allow you to discriminate between entities that want to operate in a compliant manner and are trying to operate in a compliant manner versus those that are trying to operate outside the rules or to evade the rules. And so it ends up with a waste of resources and, in many instances, energy and efforts in enforcement actions against entities that are trying to comply with the rules. And then it leaves space for others who really aren't trying, who are really trying to evade it, where they're not big enough, where they're not, they can pop on the radar early enough to merit that same type of attention. So it kind of inverted the whole way that one would think a regulatory structure should be set up.
Well, in that third bucket, turning to it, at some level, is this regulation by enforcement as opposed to rulemaking, if we take a look at the cases that have been handed down in regard to cryptocurrencies?
Well, I mean, I think that you definitely saw a resistance, particularly by the SEC, to rulemaking. I'm not a securities lawyer by training, but it was interesting to me to find out that the SEC resisted putting rules in place, for example, for allowing accredited investors to invest, and that Congress ultimately had to kind of impose that. And in fact, even if you think about Howie, that was the Supreme Court setting that. And so there's a curious kind of history of the SEC wanting to kind of preserve its discretion in all instances to kind of call it on a case-by-case basis. And that's understandable from a certain perspective, but it doesn't give any certainty at all for companies that want to try to comply with a set of rules. And so, unfortunately, historically, at least historically in the terms of crypto, the SEC has been the most resistant in regulating and the most insistent on using its enforcement authorities to try to impose viewpoints and set rules to a point where they brought cases against cryptocurrency exchanges in which they alleged that certain tokens were securities, were crypto asset securities, and therefore the exchange platforms were violating the rules applicable to broker dealers. But they had never brought proceedings against the issuers of those tokens, or made any affirmative findings through an enforcement process that those were in fact securities. And so they were simply alleging it in the complaints and then bootstrapping the allegations of broker-dealer violations against the exchange platforms based on just raw allegations that these third parties had no opportunity to comment on. So it was a really, as a former government person, was really, not the way that government should be proceeding. I think that, look, enforcement is always going to be a part of the regulatory landscape. And I think that, as we were talking about in anti-money laundering, although it was unpleasant, certainly for Ripple and I think for large portions of the industry, when FinCEN brought that action and settled out that action in 2015 with Ripple, it was meant to kind of follow through on the rule set and the guidance that it had given. And then there have been enforcement actions that FinCEN has brought, and that FinCEN together with the Department of Justice have brought, but they have largely, not exclusively, but largely been based on rules that they have articulated before. There are other examples, and those have been litigated and opposed. And I think that, hopefully that won't be the process going forward. But for the most part, enforcement has been used as a complement to, and a way, again, of enforcing a specific rule set. What market structure legislation finally holds out the promise of is through a set of directed rulemakings, including joint rulemakings with the SEC and CFTC, which is that we will get a rule set and a way for companies to comply and to know that they're not going to be subject to enforcement actions if they follow those rules. And then after that, will there be companies that don't comply? Will there be enforcement actions that are brought? Sure. And those will be, litigated as enforcement actions, but they won't be this constant issue of trying to litigate these issues of first impression, or litigate these questions where there's no guidance and where the agency is saying, well, I see it this way in this case and another way in another case.
So your arguments are very persuasive as to innocent actors, right? The person who is just trying to get started in the cryptocurrency business or expand their current businesses to include cryptocurrencies. What about nefarious actors? So, can we talk just for a moment? What are the national security risks here? And at some level, does the government's approach make sense as a way to get a handle on the potential threats and risks that are presented by this, particularly in the hands of what we might call bad actors?
Yeah. Well, look, I have a colleague who likes to kind of jokingly say that criminals and nefarious actors are early adopters of technology, and if criminals are not using your technology, there may be something wrong with your technology, right? So any technology is going to be misused by bad actors. And this was something that, again, it's interesting going back to my time in government, that it's kind of hard for government to accept that technology is going to emerge. It's going to be misused by some number of people, and it's going to be very difficult to kind of regulate the technology out of existence. And instead, as agencies, we need to figure out how to adapt. When I was, in the government, governments need to figure out how to adapt to the technology and figure out the ways to channel it, figure out the ways to give people ways to comply and indicate that they intend to comply, and then develop the tools and the techniques to find and go after the people who are working outside of those boundaries. In the cryptocurrency space, there is certainly, look, because this is value, right, that's being transacted. So we've seen, an explosion of ransomware. Ransomware existed before cryptocurrency, but cryptocurrency has accelerated the challenge. We've seen hacks, right? We've seen early on we thought we saw more criminal hacks, but as it's turned out that there may have been more national security and access to them than we thought. And then more recently, we've seen hacks conducted by nation states, by state actors. The North Koreans are notorious for hacking cryptocurrency exchanges or cross-chain bridges and stealing vast amounts of cryptocurrency to kind of support their government, prop up their government, and engage in nefarious activity. So the challenge is kind of multifold. In some instances, the same is faced by industries with respect to cybersecurity generally, right? A lot of hacking activity is really about cybersecurity. It's off-chain activity. It's servers, it's human error, it's failures of key management or access management. And so continuing to work on those issues is always an issue of concern. It's one for companies in all sorts of areas, and it carries over into the cryptocurrency space. The second thing is that law enforcement agencies and national security agencies, I think, definitely now recognize this issue they have for a number of years, and they are, in many instances, particularly at the U.S. federal level, they are centers of excellence and expertise on the challenges posed by the technology. They're also aided and supported by an industry of blockchain analytics companies and others who focus on evaluating these threats and using the blockchain itself as a tool to help trace, investigate, in some instances freeze funds. Most notably, stable coins have the ability to be frozen in place and can be done by, and that's been done through service of lawful process. Um, and uh, uh, and so really taking full advantage of those tools, not only to ideally prevent those things from happening, investigate them, identify entities that facilitate these activities, use tools from criminal investigations and indictments to sanctions, to other tools, um, to then also using that network analysis to see and understand relationships using blockchain that we might not have even been able to know without that, because we can see these relationships graphically now through the way that technology has been developed. So I think we see threats in this space. I think they are, again, they're known to law enforcement. They're known to the national security agencies. They're known to, and there's an industry that's there to support those entities and the private sector in protecting themselves against those threats, and in responding to and addressing those threats.
Alan, thank you so much for coming on the show and helping us understand the legal contours around cryptocurrencies, particularly the AML and sanctions regime, and looking also at the securities and commodities and market structure, and problems really inherent in the regulatory versus enforcement domains, and looking at how that has played itself out, as well as the national security risks that are presented here. Thank you so much.
Thank you.